right, so this is our second snippet for Reconstruction in the Gilded Age. This is going to look at the period from 1870 running up through the early 1880s with regards to legal equality for African Americans. So one way of looking at this is this period is to ask the question: did Black people in the South have a meaningful opportunity to participate in the political system? And I mean, we all know how this story ends with Jim Crow and segregation and the violent removal of Black freedom in the South. But for a brief period in Reconstruction, the answer to this question was yes, that Black voters throughout the South were active participants. They were allowed to vote, and they elected legislators. So the last of the Reconstruction amendments, which is passed in 1870, is the 15th Amendment, which purports to eliminate racial discrimination in voting, although we'll see it's interpreted in this very, very strange way. And one of the most remarkable results from Reconstruction is that former slaves are elected to the Congress. The man on the right is Joseph Raines, who was the first Black person ever elected to the House of Representatives. He was from South Carolina. And the man on the right is Hiram Revels, who was a senator from Mississippi. He's the first Black person ever makes it to the Senate. The Senate at this point doesn't have popular elections. Rainey and Revels, as was the case with every African American who goes to Congress in Reconstruction period, were Republicans. And this is a list of the Black legislators who served in Congress beginning in 1868 with Rainey and Revels and continuing on through the end of the 1870s. Now, of course, these are relatively small numbers, and they are not proportional to the percentage of African Americans, overall in the country. But nonetheless, there's something significantly symbolic about the idea of a commitment to civil rights by the Republican Party, manifesting in all of these former slaves being elected to Congress from the southern states. So it seems as if, on paper, there's a possibility that Reconstruction will work. Grant, who doesn't have a great reputation, or for many years didn't have a great reputation among scholars. There's been a lot of work on Grant in the last 15, 20 years that suggested he actually was a much better, he was very corrupt, but on civil rights issues, he was a much better president than reputation suggested. And he actually, he tried to do good on this issue. The opposition, however, increasingly moved outside of the realm of politics. White militias organized throughout the South, the most significant of which was this organization founded by an ex-Confederate general, Nathan Bedford Forrest, which he called the Ku Klux Klan. So if this is activity that we would now call terrorism, the idea was to, from these white groups, was to use violence to discourage Blacks from participating in the political process. Congress did not ignore what was going on. In 1870, through a measure called the Force Act, Congress passes a law that makes it a federal crime. And the key areas here I have in red, to essentially act in a way to prevent people from voting. Everyone knows what they're talking about here is white violence against Blacks in the South. And so and if it's a federal crime, that means it's tried in federal courts. And if it's tried in federal courts, the federal courts have teeth, and they're not going to be dominated by segregationists. And there are some prosecutions under the Force Act. And in 1871, Congress follows this up with the Civil Rights Act of 1871. There are a series of civil rights acts which are passed during this period, the most significant of which, provision of which, Section 1983, gives to people whose civil rights have been violated. And so imagine here that you're a Black person in the South who, the KKK is attempting to prevent you from voting or from serving on a jury. You have a right under the Civil Rights Act of 1871 to sue this person in federal court and basically, get them, get an economic penalty on them as a way of trying to even the score. So there is legislation on the books. The question is, how is this legislation going to be enforced? And then finally, in 1875, the last of the major civil rights legislation laws which are passed until we get it into the 1950s. The Civil Rights Act of 1875 deals with what are called public accommodations. So basically, at this point, restaurants, hotels, theaters, this sort of thing. A business that is open to the public and it purports to serve all members of the public. And the Civil Rights Act says that any of these public accommodations that discriminate on the basis of race are violating a federal law. And again, this will be enforced not by state courts that are dominated by that can be pressured by segregationists, but entirely by the federal courts. So we have these three laws: Force Act, Civil Rights Act of 1871, Civil Rights Act of 1875, that tried to achieve a degree of equality in the South. There are a couple of problems here. The first is that Northern public opinion, which of course is not, it has its own racism, is increasingly losing interest in an aggressive federal campaign to achieve racial egalitarianism. And secondly, the Supreme Court, this is Chief Justice Salmon Chase, who was a Lincoln appointee, and he's replaced in the 1870s by Chief Justice Morrison Waite, that the Supreme Court, in a series of rulings, basically guts these laws. They interpret them in narrow, counterintuitive ways that really close the doors of the federal judiciary to African Americans who are denied political rights, who are discriminated against in public accommodations. There are a series of cases. Among the most famous is a case that arrives after one of the worst political massacres in American history at Colfax, Louisiana. Louisiana is a very closely divided state in the 1870s. The Republican Party was almost all Black, with a small percentage of white Unionists. The Democratic Party was 99.999% white. There was a contested gubernatorial election in 1873. A white mob surrounds a group of Republicans, most of them Blacks, who are in a courthouse in Colfax, Louisiana. That's a relatively small town, and the people in the courthouse are protecting the integrity of the ballots, paper ballots. They're going to count. They're in the courthouse. A riot ensues. A significant number of the Republicans, disproportionately African American, are killed. And the federal government, the state government, which comes to be under the control of Democrats, chooses not to prosecute. So the federal government prosecutes under the Force Act. And in 1876, the court, in a case called U.S. versus Cruikshank, a very significant decision in the Reconstruction era, basically says, tough luck. The argument of the courts is that the Force Act, as implemented in dealing with the Colfax massacre, and this could apply to virtually any kind of enforcement mechanism on behalf of civil rights in the South, violates states' rights. The argument here is that in the U.S. system, the police power is controlled by the state governments, not by the federal government, and that there's no clear evidence that race was here. The court says, well, we suspect that race was the cause, but it's not positive, and so we're not going to do anything to enforce. The same year, in a decision called U.S. versus Reese, the court looks the other way at efforts to restrict Black people from voting in the South. There's a number of famous policies here. Some states enacted this thing called the grandfather clause. It said if your grandfather couldn't vote, you couldn't vote. Other states enacted poll taxes that were that were easy to pay for wealthier whites, but that were a challenge for the newly enfranchised slaves to pay. All of these laws had racially discriminatory effects and frankly, racially discriminatory intent. But the court in Reese says, again, tough luck. As long as a state does not explicitly say we are denying Black people the right to vote, that, that they use race in the statute, it doesn't violate the 15th Amendment. So this decision essentially guts the enforcement of the 15th Amendment. Then in the civil rights cases of 1883, the court says that the Civil Rights Act of 1875, remember that had been the public accommodations laws, goes too far. They say that's exclusively for the state level, that there's no authority in the Constitution for Congress to regulate private rights. That's exclusively done, the court says, at the states, but of course states that are increasingly under the control of white segregationists are not going to enact these kinds of public accommodations laws. So the result is a Supreme Court backlash, which, by the mid 1880s has eviscerated the sort of key Reconstruction laws from the period passed between 1866 and 1875. All right, so that brings us up to 1876, and our next snippet is going to see where we go from there.